Afternoon, good evening, everyone. Thank you for joining us today, and thank you to Lexology and IIM for hosting this webinar. Today, we will be discussing the doctrine of equivalence and taking a look at where the doctrine is at today. My name is Alec Royka. I'm an associate at Oblon in Alexandria, Virginia, and I will be presenting today with my colleague, Andrew Ollis. And just as a few kind of preliminary matters, we will be hosting some questions at the end of this webinar today. So please use the online question tool to post any questions that you have throughout the presentation. You can access that throughout your GoToMeeting toolbar. Secondly, if you're having any audio-visual problems during the presentation, please let us know by using the online question tool on your toolbar. I believe someone will be available to kind of assist you through with any of those issues. And finally, this presentation is being recorded, and the slides as well as the recorded presentation will be sent out via link to all the registered attendees. So please feel free to access that later on, or send it to any colleagues who you think might be interested in the presentation. Okay, and starting off with a kind of a brief overview on where this presentation is going to take us today. In order to first get to where the doctrine of equivalence is at today, we want to first take a little bit of a step back and look at the doctrine of equivalence as how it has evolved over time. We're going to look at a number of Supreme Court cases as well as some recent Federal Circuit cases to see how this doctrine has evolved. We'll then kind of move into some of the more, some of the issues that have kind of come up in recent years relating to the doctrine of equivalence. That's the ensnarement defense and the tangential relation exception to prosecution history estoppel. And so when talking about the doctrine of equivalence, the case law is primarily concerned with two different policy implications. On one hand, we have fairness to the patent owner, and in these cases, you can see that the courts are concerned with providing the patentees with a robust property right and preventing accused infringers or competitors of merely ripping off the invented product and making a new product that is really just only minor changes in order to avoid literal infringement. But on the other hand of that same coin, we also have the case law being concerned with notice to the public. And a patent similar to a property deed, the claims of the patent delineate the scope of the property right that patentee is entitled to. And the case law shows that the courts are also concerned with expanding the scope of the doctrine of equivalence so much so that that the public really doesn't know exactly where they can operate in this space. And so here we're going to see, as we kind of look through these cases, that the courts go back and forth, and I'll try to point out as we touch upon these cases where the court is, what policy factor the court is primarily focusing on in these decisions. And so just like any first year patent law class within law school, we're going to take a look at the Winans versus Denmead case from the Supreme Court in the 1800s. And here the patent at issue was directed to a railroad car for transporting coal. But what was unique about this invention is that the body of the car was actually shaped as an inverted cone with a trap door almost at the very bottom of the car, so that the user could remove that trap door and unload the contents of that coal car. And this was an improvement over the prior art in that it allowed the coal to be more evenly distributed throughout the car, and it allowed the car to actually hold a greater weight of coal in total. And so Denmead, seeing that this Winian's car actually decided to go and build his own, but instead of shaping the car in this inverted conical shape, he developed an octagonal shape. And so the Supreme Court here, recognizing that while Denmead's car did not literally fit within the scope of Winian's patent, nonetheless, the Supreme Court held that there should still be a finding of infringement here, noting that the exclusive right to the thing patented is not secured if the public are at liberty to make substantial copies of it, varying its form or proportions. And so here you can see that the Supreme Court is primarily focused on fairness to the patent owner in this situation. They view the Denmead product as essentially a ripoff of the Winian's patent and are looking to provide patent owners with a more robust form of property protection here. About a century later, the Supreme Court then also takes up a notable case regarding the doctrine of equivalence in the Graver-Take versus Linde Air Products case. And here the patent at issue was directed to an electric welding composition. The patent called for the use of two alkaline earth metal silicates, calcium and magnesium. And the accused product here, manufactured by Graver-Take, used silicates of calcium and manganese, with manganese not being an alkaline earth metal, and thereby avoiding literal infringement of the Linde Air patent. And so the Supreme Court, again here focusing on the fairness to the patent holder, here notes that the essence of the doctrine is that one may not practice a fraud on the patent. Here, they take a substantial look at the record and really conclude that the experts and everything that was presented in front of the district court really made it clear that the substitution of manganese for magnesium in this situation was well known within the prior art, was really not a substantial difference, took no inventive step, and essentially by allowing Graver-Take to substitute manganese here would be a fraud on the Linde Air patent and would essentially render their property right useless. Also notable here is we see a little bit of wording from the Supreme Court on their function, way, result test. A patentee may invoke the doctrine where an accused infringer's product performs substantially the same function in substantially the same way to obtain the same result. And we'll see this language used repeatedly throughout the doctrine of equivalence cases as it really becomes kind of known as the function, way, result test in order to establish equivalency. And so our third Supreme Court case, a little bit of a half century later in Warner-Jenkinson versus Hilton-Davis, and the patent at issue here was related to an improvement in the ultrafiltration process of dyes. The claim at issue here recited in relevant part a pH from approximately 6.0 to 9.0, and Warner-Jenkinson's accused process operated at a pH of 5.0, clearly outside the literal scope of Hilton-Davis's claim. But at the Supreme Court, rather than focus on whether or not a pH of 5.0 is the equivalent of a pH of approximately 6.0, Warner-Jenkinson argued that by enacting the 1952 Patent Act, Congress had implicitly rejected the doctrine of equivalence because it had enacted 35 U.S.C. Section 112, Paragraph 6. Today, this is known as 112, Section 112F, but essentially this allowed a patent holder to claim using functional language such as means plus. And as a result, that patentee would be entitled to what was disclosed in the specification as well as any equivalence of that means plus. And so the basis of Warner-Jenkinson's argument here was that by enacting 112 paragraph 6, which enabled means plus function, the Congress was allowing the doctrine of equivalence, but only for a very limited purpose. And it was for this means plus function. And they were thereby implicitly rejecting it as it was applied throughout the rest of patent law. The Supreme Court rejecting this argument noted the legislative history of 112.6, and that it was particularly in response to the Supreme Court's earlier Halliburton decision, which had rejected the use of functional claim language. The Supreme Court here noted that congressional action in order to eliminate a doctrine that had been around for nearly a century and a half needed to be done in a much more explicit manner, and that simply enacting a section such as 112.6 to imply that there was an implicit overruling of the doctrine of equivalence was not enough in this situation. Also notably, the Supreme Court had a little bit of a clarification here, and this is the first instance that we're going to see that the court is actually focused more on the notice to the public prong of that policy inquiry. The Supreme Court clarifies that when applying the doctrine of equivalence, it should be applied to the individual elements of a claim and not to the invention as a whole. And so this, by applying it to the elements and not to the invention as a whole, it provides a little bit more limitation within the doctrine of equivalence. Now, if you think in an example of a pencil and a pen, perhaps as the invention as a whole, a pen could be deemed the equivalent of a pencil. But when you look at those individual elements, applying the equivalency to the individual elements of both of those two products, it'd be much harder to find an equivalency argument. And so kind of as I briefly touched on before, the doctrine of equivalence and determining whether something is an equivalent is essentially broken down into two tests today. We have the function way result test, which we saw used in the Graver Tank decision, and we have the insubstantial differences test, which is kind of briefly almost mentioned within the Winans versus Denmead case. But looking at these tests in a little bit more detail, the function way result test is performed on a limitation by limitation basis, and the accused product is found to infringe if it performs the same function as the original, performs that function in the same way, achieves the same results as the original. Sometimes this test is merged a little bit more, such that it's worded as performing the same function in the same way to achieve the same result. But we also have the use of the insubstantial differences test, and here an element in an accused device is found to be equivalent to a claim limitation if the only differences between the two are insubstantial. Now, use of these two tests can be interchangeable, and in some of the more clear doctrine of equivalence examples, both tests would suffice. However, it is useful for patent practitioners and patentees to have both tests, as there are situations where it's perhaps easier to frame your argument using the insubstantial differences test or the function way result test. And so an early example, or actually a more recent example of use of this function way result test was in Amgen versus Sandoz, which was a 2019 Federal Circuit opinion authored by Judge Laurie. And here the product at issue focused on a process for developing a drug that was used to increase the white blood cell count in patients who were undergoing chemotherapy or radiation treatment. And the claim at issue after construction was determined to be a three-step, three-solution process to achieve a result. However, the Sandoz accused product in this situation was a one-step, one-solution process. And so applying the function way result test, the Federal Circuit noted that in essence, these two processes did not work in the same way. So they failed that kind of middle way prong of the function way result test. Judge Laurie here, kind of what was significant at the time when this opinion was issued, noted that the doctrine of equivalence applies only in exceptional cases, and that the public has a right to rely on the language of the patent claims. And so here we can clearly see that Judge Laurie is focused on the notice to the public aspect of the policy considerations relating to the doctrine of equivalence. But somewhat interesting is that about 6 months later, after Amgen had filed a petition for en banc review at the Federal Circuit, the Federal Circuit released a per curiam opinion deleting the language that the equivalence is applied only in the exceptional cases. Now, there are a number of potential reasons why the Federal Circuit would have found that this was necessary to do, but perhaps notable is that there's simply a differing of opinion related to the that the Federal Circuit judges have on this issue. As you'll kind of see later on in some of the cases that Andy discusses, is that some of the other judges on the Federal Circuit are more concerned with fairness to the patent holder rather than notice to the public. And these policy considerations kind of shift back and forth, and perhaps simply deleting the exceptional language was a way to kind of find a little bit of unity among the different Federal Circuit judges on this issue. Now, when making a doctrine of equivalence argument, before you can even get to the function way result test or the insubstantial differences test, there are a number of hurdles that a patentee must first overcome. They must overcome any potential claim amendments that they've made. So if the original claim recited a range of 4 to 7 micrometers, but then during amendment that range was reduced to 5 to 7 micrometers, it may not be possible for that patentee to later claim that 4 micrometers is an equivalent to their claim, because it may be viewed that they had given that up during an amendment process. Similarly, the courts may find that arguments made during prosecution to overcome the prior art or to specify particularly what the claimed invention is covering may also further limit the patentee's ability to claim an equivalency argument, as well as things that are listed in the specification but not claimed, and potentially the prior art, which we will see coming up in just a little bit. If a patentee is unable to essentially claim the equivalency of something that he would not have been able to claim through the initial prosecution process because it would have been unpatentable in light of the prior art that existed at the time. And so going in line with that, these hurdles can be raised by an accused infringer through a number of defenses. You have the ensnarement defense, which is a patentee cannot claim an equivalent of something that would not have been patentable at the time because it was covered by the prior art. You also have prosecution history estoppel, which basically states that a patentee cannot reclaim something that they had given up during prosecution. You have vitiation, which is a legal finding by the court that the equivalence that no reasonable juror could find the accused product and the claimed product to be equivalent. And then you also have the dedication to the public, which is where something is disclosed within the specification. However, it's not claimed. That information is deemed to be dedicated to the public and therefore cannot be reclaimed as an equivalent. So moving on to the ensnarement defense, which we had discussed, this is a defense that has really kind of become a little bit more popular within the case law in recent years. And it is really a powerful tool that an accused infringer's toolbox as a way to combat a potential doctrine of equivalence argument by a patentee. And so the doctrine of equivalence, put simply, the ensnarement defense, the doctrine of equivalence theory cannot be asserted if it will encompass or ensnare the prior art. And so what you can see here through this graphic is obviously an accused equivalent falls outside the literal scope of the claim. However, when asserting a doctrine of equivalence argument, the patentee is essentially claiming that the literal scope of the claim should be expanded to then cover that accused infringement. However, if prior art would cover that accused equivalent instead, the patentee is prevented from asserting a doctrine of equivalence argument because that equivalent would ensnare the prior art. Now, evaluating an ensnarement defense in theory is a simple task. However, in practice, it becomes a little bit more difficult. The Federal Circuit has really focused on one way, has encouraged the use of one analysis. However, it has been open to the possibility that district courts can use a number of analyses to figure out whether or not the prior art actually ensnares the accused equivalent. And a hypothetical claim analysis, the Federal Circuit had said, is a practical method to determine whether an equivalent would impermissibly ensnare the prior art. However, as mentioned briefly before, the Federal Circuit has also permitted district courts to directly compare the prior art with the alleged equivalent element to the accused device to determine whether or not an ensnarement defense can actually be raised. But looking at the hypothetical claim analysis situation, we're brought in with a two-step process that the Federal Circuit has articulated. And this is really a unique process because it goes against some of your initial inclinations during an infringement proceeding where the patentee may be entitled to a presumption of validity of his patent. But here in this situation, the first step would be for the patentee to construct a hypothetical claim that would literally cover the accused device. Now, in this situation, the patentee has his original claim, which was what he actually received his patent on, but the process here is for the patentee to essentially broaden their claim and such that their claim would then literally cover the accused equivalent. The next step in this process would be for the accused infringer to introduce prior art that would then be assessed to determine whether the patentee has carried its burden of persuading the court that the hypothetical claim is patentable over the prior art. Notably, in this situation, the patentee has the burden of persuading the court that the hypothetical claim is patentable. Unlike a traditional invalidity proceeding where the patent is entitled to a presumption of validity, because we're dealing with a hypothetical claim here, there is no presumption of validity, and the burden actually falls on the patentee to convince the court that they are entitled to the scope of that equivalency. And so looking at a case example here, we have the Jang versus Boston Scientific case. Now, the technology at issue here was a patent directed to a coronary stent. The district court found that all the patentee's hypothetical claims that were presented were flawed and declined to conduct a hypothetical claim analysis, thereby affirming the jury's verdict of non-infringement under the Doctrine of Equivalence. And the Federal Circuit on appeal affirmed this. Now, looking at the claim that was the hypothetical claim that was presented in Jang, we can see that the patentee deleted a section and also added a section. But the Federal Circuit noted here that the claim is broader because it deletes the non-parallel limitation, but it's also narrower in the fact that it then requires the connecting strut column to provide more flexibility as compared to the expansion columns. And this was a limitation that was not present in the original claim. The Federal Circuit rejecting this proposed hypothetical claim noted that their precedent has been clear that the hypothetical claim may not add any narrowing limitations and must be broader than the original claim that they had received. The district court itself is under no obligation to correct a patentee's failure to present a sufficient hypothetical claim, and therefore, by failing to present this hypothetical claim, the Federal Circuit affirmed the district court's finding of non-infringement under the Doctrine of Equivalence. And similar, we have a recent decision that was just released in January out of the Northern District of California. Here, the patent at issue was a method of analyzing biological tissue samples via mass spectrometry involving labeling a sample, a cell or lump of cells with metal tags attached to antibodies, and a process called staining. The defendant's accused process analyzed antibody metal tag stained biological samples with mass spectrometry as well, but rather than operating on cells or lump of cells, they operated on thinly sliced tissue samples, much thinner than any intact cell could potentially be in this situation. And so after a claim construction, the court found that the patentee was precluded from a finding of literal infringement. So the patentee instead had to rely on a theory of infringement under the Doctrine of Equivalence. However, the accused infringer had asserted the ensnarement defense, but the patentee in this situation had never presented or articulated a potential hypothetical claim that would literally cover the accused device. On the motion for summary judgment, the district court granted the accused infringer's motion for summary judgment because the patentee had failed to articulate this hypothetical claim, and noting that either misreading or mischaracterizing the case law, the patent owner asserts that it is the burden of the accused infringer to first identify specific prior art before any ensnarement analysis can occur. However, this is not the case, and the burden is actually on the patentee to first produce this hypothetical claim. Now, obviously, this case is still has the potential to go up on appeal at the federal circuit, but it nonetheless highlights the unique burden that an assertion of an ensnarement defense would has on the patentee attempting to assert a doctrine of equivalence claim. And with that, I will hand the reins over to Andy to discuss tangential relation exception.
Thanks very much, Alec. As Alec mentioned, I'm going to shift gears now and talk about prosecution history estoppel, and specifically some recent cases directed towards the tangential relation exception to prosecution history estoppel. And despite the name, we're not going to be talking about geometry and sines and cosines in this tangential relation discussion. Before talking about the tangential relation exception, however, we will talk about, let's see if I can get this moving. There we go. Oh, went too far. Prosecution history estoppel itself. As I think Alec has mentioned, prosecution history estoppel can either be based on a claim amendment or it can be based on arguments made during prosecution. We're going to be focusing in this discussion on amendments, not so much on arguments. And as the Festo Supreme Court case and other cases have indicated, a narrowing amendment made to satisfy any requirement to the Patent Act, so that could be 102, 103, 112, may give rise to an estoppel. And if there is an estoppel, the patent owner is barred from reclaiming the subject matter that they surrendered through the doctrine of equivalence. Now, the key here is that there is a presumption that a narrowing amendment bars doctrine of equivalence. The Festo Supreme Court decision in 2002 had overruled a federal circuit holding that had found that a narrowing amendment led to a per se bar on doctrine of equivalence arguments, and the federal circuit changed that back to being only a presumption. And then they went further and they explained that there were three ways to overcome this presumption of an estoppel. First, you could show that the equivalent was unforeseeable, the equivalent being an accused product at the time of the application. And the examples that they gave in the case were, for example, a transistor as opposed to a vacuum tube, or Velcro as opposed to a fastener, assuming that the transistor and Velcro were later developed technologies that were not available. As a practical matter, this unforeseeable exception is quite difficult to prove, and generally speaking, someone can argue, usually with some success, that almost any alternative in an accused product was foreseeable at the time the application was filed. The second exception, and the one we'll be talking about, is that the rationale underlying the amendment bears no more than a tangential relation to the equivalent in question. And we'll talk about what the tangential relation means. And the third sort of catch-all exception is some other reason that your attorney could dream up, or you could dream up, that you could not have described the accused product. To my knowledge, the third exception has not been successfully argued, but I'm sure there's always room for someone to find a way through there. So what is a tangential relation? The Festo Supreme Court decision explained generally that there's no reason to foreclose a claim of equivalence for an invention that has only a peripheral relation to the reason an amendment was submitted. The key here is the reason for the amendment. So the tangential relation discussion is going to focus on why the patent owner made the amendment. When the Festo Supreme Court decision went back to the Federal Circuit in 2003, they refined this slightly, and they explained that the tangential criterion focuses on the patentee's objectively apparent reason for the narrowing amendment. So the question becomes, what does the record show was the reason for the patent owner's amendment? In Festo itself, there were 2 patents at issue. One of them recited a claim to a linear motor having a piston, a driven assembly, and a magnet arrangement. That claim was then amended and narrowed so that the driven member included a cylindrical sleeve made of magnetizable material. The accused product didn't have a magnetizable material in their sleeve. They had an aluminum sleeve. Clearly, there was no infringement, and the issue for infringement here focused on doctrinal equivalence. Now, in this case, there was no reason that was clearly apparent in the prosecution history estoppel why the magnetizable limitation was added. And so the court concluded that because the prosecution history estoppel, the prosecution history was silent and revealed no reason for this limitation, there was no way to show that any accused product was only tangential to the reason for the accused equivalent. So while in other cases, silence in prosecution history may be helpful, when it comes to invoking this exception, it's not helpful. There needs to be some explanation, or at least apparent reason in the record why an amendment was made if you wish to invoke this prosecution history estoppel exception. Since that was not able to be done here, the prosecution history estoppel applied in that Festo patent. Now, after Festo came out in 2002 and created this tangential relation exception, there were some cases that discussed it, and in a few instances in the 2000s, the tangential relation exception was successfully argued. Probably more often it failed, and in general, it seemed that in the 2010s, this exception was becoming relatively dormant. And in 2017 and 2018, for example, there were no Federal Circuit opinions discussing this exception. In 2019, though, and 2020, that changed. In the middle of 2019, an appeal came to the Federal Circuit from a decision out of the International Trade Commission in Ajinomoto versus the ITC. Here we had another biotechnology case involving an E. coli bacteria that had been modified to increase a desired L-amino acid production by the bacteria. The claim recited a particular protein in the bacterium, and it originally gave 2 alternative ways of defining this protein, A and B, before it was amended. The first recited a particular protein sequence associated in ID number 2, and originally the second one also had a protein amino acid sequence, but the second one allowed for substitutions, deletions, insertions, and provided more flexibility. During prosecution, when confronted with prior art that apparently was covered by the B version of the protein, the claim was amended and such that the protein was described with respect to a particular nucleotide sequence instead of the original description. This protein in the prior art was called the YFIK protein, and because the element B was amended, it was considered to be a narrowing amendment and thus presumed to give up all equivalence for element B. The accused product was yet a different protein than the prior art protein. Now, this case was quite unusual for a doctrinal equivalence case for one reason in particular. Normally, when we look at a doctrine of equivalence analysis, there is a single element that is missing in the accused product as compared to the claim. And it's a comparison of one element of the claim to the accused product. Here, we had an unusual situation because option B of the definition of the protein was the version that was amended. But the equivalence allegation actually was with respect to option A, an unamended claim element. And not surprisingly, at the Federal Circuit, Ajinomoto argued that we shouldn't even be talking about prosecution history estoppel with respect to the A definition of the protein because the A version was never amended. However, the International Trade Commission's opinion below had found equivalence infringement by finding that there was a presumption of prosecution history estoppel and then finding a tangential relation exception. And so rather than take the easy way out and not address the prosecution history estoppel, the court followed the analysis and evaluated the analysis of prosecution history estoppel and the tangential relation exception of element B. And in doing that, they explained that in evaluating the tangential relation exception, we look at whether the reason for the amendment was peripheral or not directly relevant to the alleged equivalent. So here they're putting the gloss that tangential means peripheral or not directly relevant to. In looking at the prosecution history, and this is the kind of critical part in these analyses, is what was the reason for the amendment? And they said, well, the immediate reason for the amendment was to limit the set of proteins to not cover that prior art protein, and also to limit the wide range of amino acid alterations. It was not related to the other language that was added by amendment to choosing DNA sequences corresponding to the protein. Under that framing of the amendment, the court found, in fact, that the tangential relation exception to the prosecution history estoppel presumption applied. They then went through the exercise of the function way result analysis. They found that the accused protein also increased the export of the certain amino acids, and the finding of infringement under the doctrine of equivalence was affirmed. Now, this was a 2-to-1 opinion. Judge Dyke issued a dissenting opinion, disagreed on multiple points with the analysis of the majority, and particularly the technical analysis. He found that the reason for the amendment was directly related to the accused equivalent and characterized that the tangential relation exception was very narrow. So when this opinion came out after quite a long period where there were no tangential relation cases of note, it seemed easy to conclude that maybe this was an exceptional case, a close case with an unusual fact pattern, and we might not see another tangential relation case from the Federal Circuit for a while. Well, that was not the case. Only a few days later in 2019, there was another tangential relation case. This one was Eli Lilly versus Hospira, which had a simpler fact pattern. Here we had an improved method of administering pemetrexed disodium to a patient, a cancer patient. And the improvement provided that in addition to administering pemetrexed disodium, which could have some uncomfortable side effects, you also administered folic acid prior to the administration and also a vitamin B12. Now, importantly for this analysis, the original claim recited administering an antifolate, so a class of compositions, rather than simply or more explicitly the pemetrexed disodium. The accused product in this case was a pemetrexed diatromethamine, so a different salt, but still a pemetrexed. In the discussion of this case, also by Judge Lurie, he started off with a general observation that the doctrine of equivalence has been consistently upheld by the Supreme Court. But then we see creeping into the analysis again that Judge Lurie, at least, has emphasized that the doctrine of equivalence is the exception and not the rule, and not simply the second prong of every infringement analysis. Nonetheless, and here, of course, there's no question that the amendment from antifolates to pemetrexed disodium narrowed the claim, and that this was done in this particular case for reasons related to patentability. Here, they put a slightly different gloss on the word tangential, and they said it means touching lightly or in the most tenuous way. And they affirmed, again, the finding of infringement under the doctrine of equivalence, even though there had been a claim amendment here. And they focused on the reason for the amendment being to give up antifolates, not other pemetrexed salts. And under that analysis, an accused product that used a different pemetrexed salt was still subject to infringement finding under the doctrine of equivalence, and the prosecution history estoppel presumption was overcome again. Still later in 2019, there was another tangential relation case. This one dealt with an apparatus for measuring compounds in a fluid, specifically for blood glucose monitoring. And here, the claim recited a microprocessor for converting multiple Cottrell currents in the sample, these readings into analyte concentrations, and then comparing the measurements. There was no question in this case that the accused products did not convert Cottrell readings into the analyte readings as claimed. So we were into the issue of doctrine of equivalence. During prosecution history, these particular limitations that dealt with the microprocessor conversion and particularly the comparison of the various measurements had been added in order to overcome prior art. And they were also argued extensively to overcome the prior art. Nonetheless, and thus the presumption of prosecution history estoppel arose again, and the patent owner nonetheless argued that the tangential relation exception applied. Now in this case, the court disagreed with the patent owner, and the Federal Circuit found that both argument-based and amendment-based prosecution history estoppel applied. We won't get too deeply into the facts of this case, but suffice it to say that the Federal Circuit found that the accused product operated in a way that was more similar to the prior art, and thus the amendment was not tangential to the accused product. So a couple cases finding infringement under the doctrine of equivalence using the tangential relation exception, but also one not finding it. Now in 2020, there was still another case, in fact, a couple cases, we picked on this one among others, from Judge O'Malley, Biorad versus 10x Genomics. Here, the claim was directed to a microfluidic system. So we had a system where they were forming microscopic droplets that were very useful for further lab analysis. And in forming these droplets, the system had these very small non-fluorinated microchannels, and also a carrier fluid comprising a fluorinated oil and a fluorinated surfactant. The accused products in this case also had microchannels, but they had 0.02% kynar, which was a fluorine-containing coating resin. The evidence on the record here indicated that this amount of resin was really a de minimis amount of, of fluorine in the coating, and that the microchannels and the carrier fluids did not react with one another. Now, during prosecution, the claims were amended to add this non-fluorinated requirement to the microchannel. And they were also amended to recite that the surfactant was a fluorinated surfactant. The contrast being important here because that way the channel and the carrier fluid would not react with one another. In this discussion, it opened from Judge O'Malley's opinion with the statement that equivalence remains a firmly entrenched part of the settled rights of the protected by the patent, and there was no discussion at all that doctrinal equivalence might only be an exceptional aspect of infringement case law. Turning to the tangentiality inquiry, again, the focus here is on the objectively apparent reason for the narrowing amendment. Prior art had disclosed fluorinated microchannels, in particular, that would react with the carrier fluid. And the crux of the argument here then turns on characterizing the reason for this amendment. So again, if you go back to the claim, we see that we added a non-fluorinated microchannel. One logical conclusion could be that the patent owner desired to have no fluorination in the microchannel, and thus even a small amount of fluorination in the microchannel was something that the patent owner intended to exclude based on the record. But that argument didn't prevail, and instead Judge O'Malley looked more generally at what was attempting to be accomplished in the distinction of this, by making this claim amendment to distinguish over the prior art, and said that what really was going on was that the patent owner didn't want the carrier fluid and the microchannel wall to react, so they should be chemically distinct. Now, there's nothing in the claims that says that the carrier fluid and the microchannel wall should be chemically distinct. And so the battle is won here because of the fight over what was the objectively apparent reason for the narrowing amendment. And thus, in this case, a doctrinal equivalence finding was affirmed. Now, in another opinion, again in 2020, we came back to the Eli Lilly patent. Again, the treatment method for administering pemetrexid disodium. And in this case, Apotex was using yet a different salt, pemetrexid dipotassium. Apparently, during the pendency of the Apotex case, the earlier Eli Lilly versus Hospira opinion had come out, and presumably Apotex had concluded that it was going to be very difficult to argue that their different salt was not equivalent based on that opinion. But they looked deeper into the prosecution history of the same patent, and they noticed that originally the patent recited, rather than Olympta, rather than pemetrexid disodium, that the claim recited Olympta, which was the brand name of the pemetrexid disodium for Lilly's brand. This was rejected as indefinite by the examiner, and the claims were amended to instead recite pemetrexid disodium. There was then an argument about whether prosecution history estoppel applied, and if it did, again, Apotex argued that the tangential relation exception should apply. But in this case, we didn't get to the tangential relation exception, because remember, there's a basic requirement in prosecution history estoppel that in order for it to arise with an amendment, the amendment must be narrowing. And the court concluded that simply changing the name from the brand name to the chemical name, pemetrexid disodium, did not narrow the scope of the claims. And thus there was no prosecution history estoppel presumption in the first instance. And consequently, they didn't even have to reach the tangential relation exception. So that defense was unsuccessful. So we then see that when we're looking at the issue of infringement, if an accused product is missing a limitation, obviously there's no literal infringement, and that door for stopping your adversary is foreclosed. If the missing limitation in the accused product was created the claim element was added by amendment, then there's a presumption that the doctrine of equivalence is also not available, that there's a presumption of estoppel. But we know from Festo that there are exceptions, and this tangential relation exception essentially seems to be a hole in this door stopping an assertion of infringements. Characterized it as a mouse hole, but based on the last couple of years, it's possible that at least in some circumstances, a mouse of reasonable size may be able to sneak through that door. And so it's just something that's important to keep in mind, that simply noting that a limitation that could be infringed under the doctrine of equivalence was added by amendment is not necessarily the end of the analysis. Now, we also had this broader theme, as Alec has mentioned, the balance between notice to the public and protecting the patent's rights. And as part of that, we see this periodic appearance of the characterization of the doctrine of equivalence as an exception. And this year in January, there's another doctrine of equivalence opinion, the Olaf suit design related to feeder winches. So we had a mechanical case here, and it came after a jury verdict in a rather unusual situation, because the jury found that not one, but 4 different elements of the claim at issue were infringed under the doctrine of equivalence. Now, the Federal Circuit, particularly the panel here, was troubled by this, and they approached a number of typical claim construction sorts of issues, found that there had been an error, and that under a proper claim construction, it was not possible to find infringement. What was interesting, though, again, was Judge Lurie, once again, feeling the need to write a concurring opinion, and here expressing concern over the use of the doctrine of equivalence, and again, working in his comment that it is the exception and not the rule. Now, the Olaf suit case is a good illustration, again, of course, that most fights that we think of in the patent world on infringement are often resolved by claim construction. But claim construction really is just defining the literal scope of the claim. And so even if the patent holder may lose on the issue of claim construction, there may still be a fight over infringement under the doctrine of equivalence. So where does that then lead us in summary? When we're looking at a non-infringement analysis, remember the doctrine of equivalence. It shouldn't necessarily just be an afterthought, especially if we're at the phase where this particular patent is quite important. You can be sure that if they're in a commercially valuable space and the patent owner is trying to see if his patent can be used, or her patent can be used to stop a competitor, they will be looking carefully at the doctrine of equivalence. The doctrine of equivalence, as has been pointed out, is not easy to succeed on. There are many hurdles that the accused infringer can raise, but it's not impossible. And there have been a number of examples where the Federal Circuit has affirmed findings of doctrine of equivalence. The ensnarement defense has come up more recently, and it can be a powerful tool against the patent owner, because it may, and doesn't necessarily have to, but it may require the patent owner to create a hypothetical claim that covers the accused product, but not prior art. As we've seen, even prosecution history estoppel will not necessarily block the patent owner from asserting infringement under the doctrine of equivalence. The tangential relation exception has been quite actively litigated, and it has been successfully argued in several cases in last couple of years. When we look at the role of doctrinal equivalence as a whole, we can see that the Federal Circuit is sending somewhat mixed messages, maybe not from Judge Lurie, he's sending a very clear message, but we don't see other judges sending the same message that the doctrinal equivalence should only be applied in exceptional cases. So there seem to be different feelings on the Federal Circuit, at least, about its proper role in the infringement analysis. All of that said, at the end of the day, the patentee is almost always better off with a finding of literal infringement. And in general, of course, we would recommend that you obtain broader claims in the first instance, so that it's not necessary to have all of these interesting but sometimes complex discussions about infringement under the doctrine of equivalence. And with that, I think we've concluded the presentation portion. If there are any questions, we're happy to try to answer them either now via the questions tab up on the screen, or separately after the presentation is done, if that's more convenient for people. With respect to the Eli Lilly cases, I would also note just briefly that the Eli Lilly patent or counterpart in Europe has been litigated extensively on similar issues, essentially equivalence issues of infringement in Europe, in England, and Holland, and Germany, and has led to a number of opinions of significance in Europe as well. Alec, there's a question here if you feel this one.
Yeah, so we did have one question submitted, reading, for the hypothetical claim analysis, is there an argument that a claim that is broader as a whole could be accepted under the test, even if there is some narrowing? So while this would be ideal for a patentee in this situation, the case law is pretty clear that a patentee's hypothetical claim may not add any narrowing limitations. And I think, just kind of theorizing on this a little bit, this goes a little bit towards that that notice to the public policy expectation within the doctrine of equivalence. And so I think the idea is that if you allow a patentee to both broaden and narrow their claims, you're essentially giving a patentee a second bite at the prosecution apple with the information now that they now have to their benefit. And that would allow them to kind of wiggle around the prior art in order to encompass this device that previously should have been free for anyone to use because it was covered by the prior art.
Thanks, Alec. I think that's right. I think the court is concerned in that case that if you're also narrowing, as Alex said, that it starts to look like you're being given too much freedom to do wholesale redrafting of your claims, and that makes the court uncomfortable. So that's presumably why they don't allow it.
And so I think it also shows that with this hypothetical claim analysis, this defense, the ensnarement defense, really proves to be a powerful tool for an accused infringer, especially in areas where there's particularly crowded prior art, because it becomes very hard for the patentee to find a way to solely narrow the scope of their claim without limiting it in any way.
One other general question. Oh, sorry. One other general
just
question
as a
that
little
comes
bit.
up.
Go ahead, Andy.
Is why do so many of the doctrine of equivalence cases seem to be in the chemical and biotech spaces? There certainly have been some and are some in the ones we discussed, and more in the mechanical arts or electrical arts, but there do seem to be disproportionately in the chemical and biotech spaces. We don't have a specific, a good answer to that question. One possibility is that many of the terms used in the chemical arts in particular, and also the biotech field, are more precise in terms of exactly what is being claimed, and than some of the terms that are typically used, certainly in the mechanical arts, for example. And so maybe that's part of the reason that it lends itself more to that area. But frankly, we don't. I don't think we have a definitive answer to that question. But it's something that's been observed, and the trend seems to continue year after year that we see it more often in those technical areas.
And just kind of as a procedural point on how the ensnarement defense and the hypothetical claim analysis works in practice, primarily because the ensnarement defense is a question of law, which is decided by the judge, you will primarily see this being brought up on a motion for summary judgment or a motion for partial summary judgment. And some district courts even choose to address this after a potential jury verdict on a JMAL motion. They'll actually wait to see whether or not they'll let a doctrine of equivalence argument go forward, and they'll wait to see whether the jury has found equivalency and infringement under the doctrine of equivalence, and only then will they choose to address the ensnarement issue. But as a procedural aspect, one of the best examples that I could find was Judge Stark within the District of Delaware in the Siemens versus Westinghouse case, where he actually he ordered the parties to submit a joint statement, essentially laying out how they would like to handle the ensnarement defense. Obviously, the patentee in the situation claimed that a hypothetical claim analysis wasn't necessary, while the accused infringer said a hypothetical claim analysis was probably the best bet to go. Judge Stark, recognizing that while the hypothetical claim analysis was an optional procedure, he felt that it would be helpful to him in analyzing the ensnarement defense, and kind of set up a scheduling order for the parties to follow, whereas maybe 14 days after that order, the patentee would be directed to submit a hypothetical claim, and then following a few weeks after that, the accused infringer would then submit the prior art.
Thanks, Alec. Okay, well, I think we are just coming up on the hour. So we wanted to thank everyone for taking an hour out of their afternoon or evening or morning, depending where you are, to listen to our discussion. We really appreciate it. Again, if anyone has any other specific questions that they would like to ask either Alec or myself, you're welcome to reach out directly and contact us after the presentation. And again, thanks to everyone. Hope everyone has a good day. Thank you.